Hello, everyone, and welcome to Uncivil Law. For today's case, we have a situation dealing with automatic plate readers. This is the situation in United States of America versus Jay Yang. In this case, the federal government came into knowledge that someone was stealing mail. They used data from automatic plate readers that scan license plates and put them into a private database as part of the way of obtaining the criminal conviction. The issue at bar here is whether or not this is illegal or whether or not it violated Mr. Yang's rights to use this privately collected data as a method to track his movements and determine who the criminal was. So we're going to read this case. Let's get started with this. In April of 2016, the United States Postal Inspection Service received information that mail theft was occurring at the Summerlin Post Office located in Las Vegas, Nevada. I've often privately commented that if you were going to be a law enforcement officer, postal inspector is pretty good because your jurisdiction is the mail, and the mail goes everywhere. So postal inspectors have quite a bit of latitude in law enforcement because they can go anywhere the mail goes, which is essentially all the places worldwide. So, as far as jurisdiction goes, it's not a bad gig if you're looking for something to do. The other one I thought that would be interesting for me personally, if I wanted to go into law enforcement route, I always thought the counterfeiting law enforcement would be interesting, which you may know is done by the Secret Service. I don't know. I just think it's really interesting looking at money and how it's being done. So, those would be my pro tips. If you're looking for law enforcement, postal inspector, or Secret Service dealing with counterfeiting, these are my recommendations. Let's press on. On April 6, 2016, Postal Inspector Steele, great name, obtained video footage from surveillance cameras at the Summerlin Post Office, which showed a person engaging in phishing, a method of stealing mail from mailboxes in which an individual lowers an object, which usually has adhesive or some grasping mechanism, into a box and retrieves mail from the box by pulling it out with the object. So, this person's brilliant criminal scheme was to go into a post office and to try to rob a post office box by putting an attachment in the box in order to steal mail from the boxes. Why? I don't know. This seems like a very strange criminal enterprise, but this is what he was doing. Okay. The surveillance footage showed that on April the 5th, 2016, at 2:17 a.m., a slim Asian or white male with short hair exited a dark-colored GMC Yukon and placed the phishing device into a collection box. Although April the 5th surveillance footage showed the individual losing his phishing device in the box prior to removing the mail, he lost his thieving tool. That's sad. Surveillance video on the 6th, 7th, and 8th showed the same individual exit the Yukon and use, presumably, a different phishing device to remove mail from the collection box. So I don't know what he was looking for, if he was looking for a particular piece of mail or what, but this is what was happening. On April the 7th, 2016, afternoon surveillance video from the Summerlin Post Office revealed another vehicle, this time a budget rental truck with an Oklahoma place to what appeared to be the same driver. So he's using different cars as part of his mail phishing plan. On April the 9th, it was again observed in the surveillance video from the DMV, and on April the 11th, the inspector checked the DMV records for the Yukon. There, he learned the Yukon had been reserved and rented on a third-party website by Jay Yang. So he learned who this thing was rented by. Jay Yang. Pretty good tip. The contractual rental period began on the 2nd, and the vehicle was due back on the 5th, but it had not yet been returned. So this inspector, basically 3 days after the first mail phishing incident occurred, this inspector's on the scene trying to figure out what's going on. He's looking at the records. He follows it up. He finds out it was rented through a third-party company. He finds out who it was rented to and that it was overdue. So he has a pretty good lead. Okay, so far so good. Inspector Steele testified at the suppression hearing to suppress the evidence that the Prestige had attempted to repossess the vehicle by activating the GPS unit and remotely disabling the unit. So Prestige is the name of the rental company or rental company service. So they had learned about this and tried to repossess their car because it was their car. So fair enough. Inspector Steele was also informed the vehicle was not at the location identified by the GPS, and GPS unit was no longer functioning, apparently having been disabled by a third party. So our thief is partly clever, which is the problem of many criminals. They're partly clever. He rented a rental car. He disabled the GPS in the car, but he rented using his real name. So, half thought through plan, needs work, but yeah. On April the 12th, Inspector Steele contacted Budget Truck Rental and obtained the rental information for the budget truck. So, having previously obtained the information for the Yukon, now let's obtain information about the budget truck. And that too had been rented by Jay Yang, again, using his real name, left something to be desired. So far, so good. Nothing controversial going on here. We have surveillance video from the post office. We have captured this vehicle or vehicles on the surveillance footage from the postal office. We know what car it was used. We apparently could get their plates. We know what the guy looks like. We have tracked down information concerning this person. So far, so good. Next is the part where this becomes a little bit controversial, at least according to Yang. This is the part where this inspector is now going to go into information not from the Postal Service, their own cameras, their own devices, but into third-party information. So the question is whether or not they could use this third-party information as a method of investigating the crime. So let's read a little bit about these automated plate readers and how that information was used in the investigation of this crime. On April the 13th, 2016, Inspector Steele requested a vehicle detection report for the Yukon through a license plate location database called Learn. The Learn database was created and is maintained by a private company named Vigilance Solutions. Cool name, I guess. The Learn database receives license plate images from digital cameras mounted on tow truck, repossession company, and law enforcement vehicles. These camera-mounted vehicles photograph at 30 frames a second, which is fairly typical for video, right? Any license plate they encounter while traveling in the course of their ordinary business. So as they're driving around, these cameras scan license plates as they're going by. If you've ever seen cop cars, they'll sometimes have these pointing both directions to capture license plates. So I've definitely seen these in the real world, and I suspect you have too. The automated light plate recognition technology located on a laptop inside the vehicle interprets the characters depicted on the plate into machine-readable text and records the latitude and longitude of the vehicle the moment it photographs the plate. So these cameras are connected to a computer. The computer has some image recognition software. In the case of a license plate, that's not particularly hard computationally because they're all written in very easily understood, clear fonts. So as far as image recognition goes, not too complicated. They then record that information along with latitude and longitude and time of exactly where that plate was seen. And you can see how in the aggregate that might become a problem because you can see exactly how people are traveling, exactly with this aggregation data, what people are up to, and that can become a little bit concerning. But does it present a legal problem for the police? Let's read on. The software also generates a range of addresses estimated to be associated with the GPS coordinates, so it'll tell you what the address is. Okay. The information is updated and stored in a database for years after collection and searchable by law enforcement and government agencies that pay the subscription fee. So for years, decades, you can get information where those plates were spotted. Does that present a problem? Let's read on. At the suppression hearing to suppress the evidence, Mr. Hodent, the president of the holding company of Vigilance Solutions, testified there were approximately 5 billion license plate scans and affiliated data located in the Learn database, and on average, the license plate for any particular vehicle is scanned and uploaded to the database approximately 4 times per year. So on average, according to the president of this company, on average, every single license plate is captured 4 times per year. On average. Obviously, not all license plates because some cars stay garaged and wouldn't be on the roads, but on average, every single license plate is captured 4 times per year. That can be significant. Inspector Steele testified that his queries about the Learn database have sometimes produced 1 record, sometimes 20, and sometimes none at all. Yeah, because these are just records that are being created through happenstance. As the cars are going upon their normal business on the roads, they are capturing the plates. So depending on how frequently you travel the roads that cop cars, repossession vehicles, tow trucks are traveling, one would presume that would roughly correlate to how frequently your data would be in this database, yes. The Learn database continues to grow. The Amici brief notes that as of March 2019, it was estimated the company's commercial database alone had grown to include 6.5 billion scans. So at the suppression hearing, the president of the holding company said 5 billion. But in 2019, that had been 6.5 billion. So in the intervening 2 years or so, they had gained almost a third more of their entire database. So it's growing rapidly. So based on all this information that he had obtained, based on all the data that he had pretty good information of this particular suspect and decided to actually go try to figure out if this person was the person who was doing these things. So now, having obtained all that information, having confirmed his suspicions as best he can, he's now going to go into the real world and follow up on that data. So what happens next? Going back in time to where this all originated, in April 25th, 2016, Inspector Steele and the Postal Inspector Hudson engaged in a ruse by attempting to deliver a package to a fictitious person located at a particular address. Inspector Hudson knocked on the door and was identified by mail, who identified himself as Jay Yang. So the postal inspectors were able to track down where he lived. They wanted to confirm he lived there. So, under the pretense of being a package delivery service, they knocked on the door and said, "Is Mr. So and so here?" And said, "No." I was like, "Oh, what's your name?" "Oh, my name is Jay Yang." "Okay, sorry, sir, for the inconvenience. But now we know that it's you." Good. On May the 6th, 2016, a search warrant was served on the residence of that same address. Yang, along with 3 other individuals, were present at the residence when the search warrant was executed. Therein, the law enforcement found the phishing devices. These are the devices to reach into mailboxes, numerous pieces of stolen mail, and Phoenix Arms model HP-22 pistol. Yang waived his Miranda rights. Never a great decision. Don't do that. Not that it would have helped you super much anyway, but keeping your mouth shut would have been a better plan. And he agreed to speak to law enforcement. During his conversation with law enforcement, Yang admitted to phishing from the collection boxes in the area, including the collection boxes at the Summerlin post office, and stated that he used devices like those found at his residence to steal the mail. Yang also admitted to owning the firearm that was covered from his bedroom. So it's not that the police couldn't have pieced together all this information anyway. They already had all the components. They could have put this on the stand. But it's so much easier coming from your mouth. It saves time. He said these were the devices he used. He said that was his gun. So rather than putting on a bunch of people to make a chain, we're just going to say, yeah, he said that. It reduces the complexity of the issues for the government. So I'm pretty sure they would have been able to get all that in at trial anyway, but it makes their life a lot easier. Don't make the government's life easier. It will help you in plea negotiations, if nothing else. The harder the government's life is, the more likely they are to want to make a deal, because they, like everyone else, are looking to make their lives easier. So if you make their lives harder by making issues more complex, your lawyer will have a better odds of getting a more favorable deal. So don't confess to the police. Even if they already know everything, even if you confirm everything they already know, it's so much better coming from your mouth, so much more effective. So just don't do it. Don't make their life any easier than it has to be. In July of 2016, a federal grand jury in the District of Nevada returned an indictment against Yang, charging him with receipt of stolen mail and possession of a firearm by a prohibited person. Because, as will surprise absolutely no one, this person already had criminal convictions that prohibited him from owning a firearm. So, there's that, yes. In October of 2016, Yang moved to suppress the evidence seized from his apartment and the statements he made to law enforcement on the basis the search warrant obtained by the Postal Inspection Service relied on evidence that was obtained illegally. So fruit of a poisonous tree is what he's attempting to argue. Yang offers that this automatic license plate recognition technology used by Inspector Steele without a warrant to track and locate the Yukon within Yang's gated condominium complex constituted a search under the Fourth Amendment. The suppression motion was fully briefed. So, as I indicated, they went to the apartment to try to figure out where he lived. Well, how did they do that? Because they were rental cars. And presumably the rental applications didn't provide his true address, although they provided his true name. So they couldn't get his address from the rental car applications, but they knew who they were looking for. So how they determined where he lived? Well, the way that they did this was using the automated license plate recognition technology. That's where it comes in. That's how they figured out where he lived. And then when they went to the condominium complex, they saw the rental car they were looking for in the condominium complex. That was a clue. And then from there, somehow figured out what apartment he lived in and knocked on the door and said, "Hey, are you so-and-so?" Or maybe they didn't know what apartment he lived on. Maybe they literally knocked on every single door and said, "Hey, I'm delivering a package for Mr. Smith. Are you Mr. Smith? No, what's your name? Oh, okay." Maybe they did that. I don't know. But one way or another, they figured out what apartment he was in, knocked on the door. Then, because they knew he lived there, because they confirmed the name and they knew the name on the rental application, they were able to get a search warrant. No problem, easy. They had plenty of evidence to get a search warrant. They had the video evidence, they had the trucks on file. They said it's the same guy. Judge signs off on that, no problem. They go to the apartment, they conduct a search. They say, "How'd you like to talk to us?" And he says, "I'd love to talk to you." That sounds great. Wonderful. What are these devices here? These are the devices I use to steal the mail. Okay. And what is this firearm? Oh, that's my firearm. Okay. So that's basically what happened. And now he's on trial. He's very, very sad. He said, "Well, you wouldn't have been able to get to where I live without this automated license plate recognition technology. This infringes on my rights. You wouldn't have been able to get the warrant for the address without that step. So it's fruit of a poisonous tree." All right, let's read on. In its written order denying Yang's motion, the district court held that there was no common law trespass because the license plate and associated location were only captured when the vehicle traveled on the public street. No officer placed any device on the Yukon or used technology targeting Yukon, which would have permitted the officers to peer into an area thought to be private by Yang or others, and Yang did not have a reasonable expectation of privacy in observations of the license plate reader that was driving on the streets. The district court also held there was no electronic trespass had taken place that might implicate a reasonable expectation of privacy because the location information was not generated by Yang electronically or digitally surrendering private or confidential information to third party working in cooperation with law enforcement. The location information for the Yukon was not identified by use of invasive digital technology regarding his whereabouts or those of Yang, and the information obtained was obtained through random observations recorded on the street. Okay, so there's quite a few things going on there that we should probably talk about. There was a case a couple of years ago in the United States Supreme Court. I believe the name of the case was called Carpenter because that was the guy's name. And in the case of Carpenter, what the police did in that particular situation was put a bug on the guy's car physically. They physically attached a thing to the car to track it. And the Supreme Court said, well, that's a trespass. It's a trespass to chattel. It's his car. You have trespassed his car by putting it on his car. You can't do that. So the Supreme Court struck it down on that grounds. And so the court here is analyzing that case and looking to see whether or not there's anything like that here. So it's like, okay, there's no physical trespass or electronic trespass. They didn't put anything on his car. They didn't surveil it using some sort of unexpected technology. This has come up incidentally in the Fourth Amendment context in searching people's homes. There's case law dealing with using infrared to search people's homes on the idea the infrared is leaking into the space and anyone can see it. But the court said people don't usually use infrared, so that's an invasion of privacy. Even though it's in plain view of the infrared, it's not in plain view of the normal mechanisms you have. So that's the kind of thing they're referring to. So in the same way you can't search a house without a warrant, you can't search a house without a warrant using infrared. You can search it using a camera because you're just seeing anything you could see, but not an infrared camera because that's augmenting in an unfair way. So that's the kind of thing they're talking about here. So they weren't using some technology that is unknown or uncommon or physically attaching it in some way. It wasn't information that Yang himself generated, that he himself submitted to a corporate provider. It was created by a third person. So there's none of those indicators that would exist in that kind of case law when there's nothing here that would attach in the literal sense of attachment to the ideas that were being expressed in that case. So that's the kind of thing they're talking about. There's no unusual technology, nothing that's peering into a private space that you'd have an expectation of. They weren't looking through his window to see the license plate in the middle of the car. The license plate is on the exterior of the car. Anyone can look at it at any time. So it's not a place that one would normally consider to be private. It's not using unusual technologies, no physical trespass. So there's none of those kind of indicators. And that's why the Supreme Court, this is why this particular Court of Appeals is using that analysis, because they're using the case law that has been established to reason. So let's carry on. Yeah. Well, night vision. Yeah, I think night vision would come out the same way for the same reason. I'm pretty positive the cases I'm talking about, at least the ones not in my own head, I think they're from like the late '70s or early '80s when the I think it was the U.S. Supreme Court that decided those cases dealing with infrared because the police were using infrared cameras to search for marijuana, and the court said no, you can't do that. I think night vision would probably come out the same way for the same reason. Night vision is augmenting the visual spectrum, so it's just making it's just that's a little unfair. It's just making things brighter. It's a little unfair because it's a little bit more complicated than that, but um, it's augmenting the visual spectrum. So I think it probably comes the same way for night vision. If you're trying to search someone's home using night vision, I'm not sure what that exactly would mean, but it'd be an interesting argument. But I think we come up the same way for night vision. But the cases I were thinking of were definitely infrared because they were searching for large energy sources, large lighting sources to search for marijuana was what the reason they were doing it. So yeah, yeah. That is, and that's also a fair point, Tater, because the one of the ways the court reasoned the decision, as I remember it, was because it was somewhat uncommon technology, and obviously it's become more common. So presumably you could revisit that issue on that basis, but not so far. The district court accepted a plea and sentenced Yang to 35 months in prison and 3 years of supervised release, which for interfering with a male and being a prohibited person in possession of firearms, not a bad deal, because that's pretty good work. But only 35 months in prison, so he got a pretty good deal. But he appealed anyway because he's sad. Does he have the right to be sad? Let's press on. So, to figure out whether this is in violation of the Fourth Amendment, we need to go over the Fourth Amendment standards and what that does or does not protect. So, let's discuss the Fourth Amendment and how it relates to this situation. Whether an individual has a Fourth Amendment privacy interest normally embraces two questions, as defined by Bond versus United States in 2000. First, we ask where the individual, by his conduct, has exhibited actual expectation of privacy. That is, whether he has shown he sought to preserve something as private. And second, we inquire whether that expectation of privacy is one society is prepared to recognize as reasonable. So when it comes to privacy, it can be thought of, to put it in slightly different language, as objective and subjective. And you need both in the case of the Fourth Amendment. You need both objective and subjective. So if you personally don't treat it as private, it doesn't matter. If a normal person would normally keep it private and normally hold it close, but you don't, you have the right to forfeit your own rights. So if you want to make things open that are normally closed or restrained, that's your prerogative and no one's going to stop you. So that's the subjective element. You have to subjectively believe it to be and treat it as though private. You have to treat it in a private, constrained way. And the second element is that society as a whole has to be prepared to recognize that privacy interest as reasonable. So some people can be really paranoid and want lots of things to be private. Don't ever look at me. Don't ever. You walk down the street. Don't ever look at me. It's like, but you're in public, man. The space belongs to everyone. You can't insist on your own privacy in a public space, for example. That's not reasonable. So if you want privacy in your home, if you want privacy in your car, you want privacy on your phone, you want privacy on the internet, that's more reasonable. If you want privacy walking down the street, not so much. So no matter how private you might want to be, it doesn't count. So you need both the subjective and the objective expectation and treatment of as privacy. The burden of proof is on the defendant to demonstrate the reasonable expectation of privacy in the subject of a warrantless search. Again, this goes to warrantless searches because if we had a warrant, we wouldn't be worrying about this. We'd be asking different questions. We'd be asking about the basis for the warrant. But we're talking about a warrantless searches because the Fourth Amendment protects unreasonable search and seizure. So if it is reasonable, then the Fourth Amendment doesn't have anything to say about that. So it has to be an unreasonable search. If you have a warrant, it's not a problem. So we're talking about a warrantless search, whether or not it's reasonable or unreasonable. This case, they didn't have a warrant when it came to this private database. They just paid a membership fee and joined the database and got it as part of their membership. So there wasn't a warrant as to that. Now, ultimately, for the search, then the rest, there wasn't a warrant for that, of course. But we're talking about the search of the license plate database, whether that was protected or not. At the outset, we reject Yang's argument that the above-mentioned cases are an opposite because they regard an expectation of privacy in property or premises rather than the expectation of the whole of one's movements that's the issue of this case. So Yang says you've cited a bunch of cases that talk about expectation of privacy in property or premises, individual situations. But what I was arguing was an expectation of privacy on the whole of movements. So I was arguing a different aspect. The court continues. We're simply unwilling to conclude that person has reasonable expectation of privacy in his movements as revealed by historical location of data of a rental vehicle after failing to return the vehicle by contract due date when there is no policy or practice of the rental company permitting lessees to keep cars and simply charging them for extra time. In this case, the rental contractor provided the vehicles not returned will be reported as stolen by the authorities. So here they're also pointing out that it wasn't even his license plate. It was a license plate of a rental car that he didn't have the rights to. So it wasn't even his car. At that point, it was stolen. And the company had some rights maybe to the information, possibly, but not you. It's not your stuff anyway. Also, he's arguing this collection of stuff that is a problem. So he's saying the prior cases the court cites deals with individualized expectations on property, land, home, that sort of thing. What I'm arguing is my interest in collections of movements. Now, what he's alluding to, and I don't know that the decision actually uses this terminology, but what he's alluding to is sometimes what is called the mosaic theory of the Fourth Amendment. So a mosaic is a type of picture that the individual pieces don't look like anything in particular. But when you put the pieces together, it forms a complete whole. So you can take a bunch of individual fragments and put them together to form a picture. And sometimes you'll see this where the individual elements are like photographs or pictures in and of themselves, but they're put together in an arrangement based on the lightness and darkness of the colors to form an overall picture. So that's a mosaic. On an individual level, they're meaningless. They don't say anything about the whole picture, but only together do they form the whole picture. So that's a mosaic. In the same way, they call it mosaic theory in the Fourth Amendment. They say the individual elements are nothing, but as a combined whole, they form this mosaic that's a violation of rights. So this is an idea that's been played around with by some of the courts, this idea that a collection of things that are individually not objectionable or not illegal, somehow in a collective whole becomes illegal. No court has so far accepted this idea. There have been many academic papers written on the idea. It's something that people have been playing around with as a concept to try to limit the scope of some of these collection technologies, because in the era of big data, the ability to collect individual elements that themselves are nothing into a combined whole that is more problematic is a concern. And so one of the ways that lawyers have been trying to play with this is through this mosaic theory. And so I don't know if the court actually used that language at any point, but at least as far as Yang is concerned, they're not going to adopt it here. As far as I'm aware, no court has adopted it yet. There's a lot of foundational problems with it. There's a lot of when does too much become too much. There's a lot of originalism problems with it, but it is a concept that some people have been playing with, and Yang was trying to take advantage of that, but not so much. The development of the law just isn't there yet, if it will ever be there. So not so far. There is no evidence in the record to suggest Yang notified Prestige, the rental car company, of any intent on his part to extend the rental period. In addition, the rental contract warned lessees that Prestige may repossess a vehicle if not returned by the contract due date, and a $250 fee will apply. And in case there's any lingering doubts about whether Yang had a reasonable expectation of privacy in the location of the Yukon at the time Inspector Steele searched the Learn database, we conclude that Prestige's private attempts to repossess the Yukon by activating the GPS and disabling the vehicle placed Yang, the sole authorized driver, on notice that Prestige did not intend to extend the lease term, but rather sought to repossess. So that is the end of the case of United States of America versus J. Yang. In this case, we learned that Mr. Yang was convicted of phishing mail from post office boxes. Why? Who knows? But he was. And he was also in possession of a firearm, even though he was a prohibited person. The government, as part of figuring out who he was and where he lived, used a private database full of license information to figure out his location. Mr. Yang, in turn, argues that this was improper because this collection of information violated his rights. The Court of Appeals disagrees. They say that there's no constitutional law violation in the police using this database to figure out his location and movement. It doesn't touch on a physical trespass, It doesn't use any unconventional or unusual tools. There's no expectation of privacy in a license plate. It's not held in private. Anyone can see it. Anyone can take note of it. So there's nothing there. And we're not going to adopt a compilation theory that so far has not been adopted by anyone to protect you. So there is no problem in the government using this information as part of its search in this particular fact pattern. And that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.